Madame le Connétable de Saint-Laurent.
Présente.
Monsieur le Connétable de Saint-Brelade.
Présent.
Monsieur le Connétable de la Trinité.
Présent.
Monsieur le Connétable de Saint-Pierre.
Présent.
Madame la Connétable de Saint-Martin.
Présente.
Monsieur le Connétable de Saint-Jean.
Présent.
Monsieur le Connétable de Saint-Clément.
Présent.
Monsieur le Connétable de Grouville.
Présent.
Monsieur le Connétable de Saint-Ouen.
Présent.
Monsieur le Connétable de Saint-Marie.
Présent.
Monsieur le Connétable de Saint-Sauveur.
Présent.
Monsieur le Deputy Southern. Madame le Deputy Labbé. Monsieur le Deputy Tadier. Monsieur le Deputy Luce.
Présent.
Madame le Deputy Dublé.
Présente.
Monsieur le Deputy Morel. Madame le Deputy Lehegara.
Présente.
Monsieur le Deputy Ayer.
Présent.
Monsieur le Deputy Ward.
Présent.
Madame le Deputy Alves. Madame le Deputy Gardner.
Présente.
Monsieur le Deputy Ghost. Monsieur le Deputy Farnham.
Présent.
Madame le Deputy Moore. Monsieur le Deputy Mezek.
Présent.
Monsieur le Deputy Ozef.
Présent.
Monsieur le Deputy Balash.
Présent.
Monsieur le Deputy Coles.
Présent.
Madame le Deputy Porray. Monsieur le Deputy Wall.
Présent.
Madame le Deputy Miles.
Présente.
Madame le Deputy Scott.
Présente.
Monsieur le Deputy Renouf.
Présent.
Madame le Deputy Curtis. Madame le Deputy Feltham.
Présente.
Madame le Deputy Binet.
Présente.
Madame le Deputy Jeune. Madame le Deputy Miller.
Présente.
Madame le Deputy Howell.
Présente.
Monsieur le Deputy Binet. Monsieur le Deputy Ferry.
Présent.
Madame le Deputy Kovac.
Présente.
Monsieur le Deputy Curtis. Madame le Deputy Ward.
Présente.
Madame le Deputy Wilson.
Présente.
Madame le Deputy Stevenson. Monsieur le Deputy Andrews.
Madame le greffier.
Prions Dieu, notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et la puissance de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton Saint-Nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir le cœur et les affections de tous ceux qui la composent, et de les conduire toi-même par ton Saint-Esprit, que toute la délibération étant accompagnée de ta bénédiction, réussisse au bien et au soulagement du peuple qui te plut de commettre le soin. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant « Notre Père,
qui est aux cieux,
ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel.
donne-nous aujourd'hui notre pain quotidien.
Et nous pardonne nos offenses,
Offenses, comme nous pardonnons à ceux qui nous ont offensés.
et ne nous induis point en tentation,
Mais délivre-nous du mal. Car à toi le règne, la puissance et la gloire,
au siècle des siècles. Amen. Monsieur le Deputy Southern,
Défaut.
Madame le Deputy Labbé,
Défaut.
Monsieur le Deputy Tadier,
Présent.
Monsieur le Deputy Morel,
Présent.
Madame le Deputy Alves,
Défaut.
Monsieur le Deputy Ghost,
Sir, I believe the Deputy Ghost is still away on State's business.
Yes, state's business.
Sir, can I just ask, I meant to do this yesterday but was too slow. Could we know what the state's business is when people are away on state's business? It would be helpful.
Yes, sir. I believe Deputy Gorst is in Washington attending meetings with US stakeholders about Pillar 2 implementation.
Very well, state's business.
Madame le Deputy Moore,
Deputy Moore is also away on the state's business. She is attending a workshop organised by the Speaker at Westminster.
A function organised by the Speaker at Westminster. The Speaker of the House.
Correct.
Yes. Very well. Business.
Madame le Deputy Stevenson.
Sir, Deputy Stevenson has a medical appointment and she said she will try and get here as soon as she can.
Excuse me? You haven't called Deputy Jean again?
Oh, sorry. Madame le Deputy Jeune.
Sir, Deputy Jearn also has a medical appointment and she will be here as soon as she can and sends her apologies.
Very well, excuse me?
Thank you. Thank you.
Sir, may I raise a defo on Deputy Alves?
Yes, the defo is raised. One moment. Got to find where that is now. I'm sure I'll find it at some point. Right. Defo is raised on Deputy Alves. Before we continue with public business, members may have noticed a new face within the chamber in the form of a new Deputy Viscount. That's in the person of Advocate Matthew Berry, who formerly was with the Law Officers Department as a senior legal advisor and has now moved into the Viscount's Department and took the oath of office of Deputy Viscount. And I'm sure members would wish to welcome him in the traditional way. Very well. He'll now slip away unobtrusively at some point. And we will continue with public business. The next item is the Draft Financial Services Disclosure and Provision of Information Jersey Amendment Law P49, lodged by the Minister for External Relations. The main respondent is the Chair of the Economic and International Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Financial Services, Disclosure and Provision of Information Jersey Amendment Law 2000, a law to allow the Commission to disclose beneficial owner information to assist financial services businesses with customer due diligence obligations under the Money Laundering Jersey Order 2008. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Mr. Miller, I believe you're a rapporteur in this matter.
Yes, sir. Thank you, sir. Sir, Jersey has always taken its responsibilities regarding combating financial crime seriously and is rightfully proud of its globally recognised regime. The recent publication of the Moneyval report was a significant milestone for Jersey as an international finance centre, and while there are a few areas for further improvement, the report provides an independent acknowledgement of the effective framework that Jersey has developed. As members will be aware, the report confirms that Jersey has one of the world's top-rated regimes for preventing financial crime and that we are ranked as a leading international finance centre. One of Jersey's particular strengths, as highlighted in the report to this proposition, is our approach to company transparency and its effectiveness. Jersey has a long-standing companies registry which was established in 1989 and is operated by the Jersey Financial Services Commission. It has a track record of not only meeting international standards, but leading in them. The recent Moneyval assessment identified that Jersey has a wide range of mitigation measures to address transparency of the beneficial ownership of companies, in particular, a fully populated register with thorough checks, risk assessment, verification, and registry supervision. In accordance with the international standards set by the Financial Action Task Force, the global watchdog on financial crime, Jersey has effective mechanisms for disclosing registry information with law enforcement and tax authorities in Jersey, the UK, Europe, and indeed across the world. Our long-standing approach has been to provide access to this information to those bodies who are directly involved in combating financial crime. Recent international policy discourse, however, has considered a disclosure of this information with other parties for the purposes of preventing money laundering and terrorist financing. The Financial Action Task Force, in its updated guidance on beneficial ownership, which was published in March 2023, recommended that countries consider facilitating access to persons who are obliged to perform customer due diligence, known as obliged entities, to support them in this process. This includes banks and other financial services businesses. The solution proposed through the proposition will ensure that Jersey complies with this best practice and will enable the Jersey Financial Services Commission to disclose information to obliged entities for the purposes of supporting the performance of customer due diligence. This will benefit not only those who need to complete due diligence process, but also their customers and clients. Jersey is committed to delivering further appropriate transparency to beneficial ownership information as part of its continued commitment to fighting financial crime. This was confirmed in our 2023 joint commitment with Guernsey and the Isle of Man. Members may be aware that work is ongoing to develop a policy for access for those with a so-called legitimate interest. At present, we are consulting with other stakeholders as well as monitoring developments in other jurisdictions, in particular member states of the European Union. That work will consider how countries worldwide are defining legitimate interest and how access can be provided while still respecting data protection, privacy and human rights issues which remain of critical importance. This, however, is a debate for another day, as this proposition is limited only to providing access to obliged entities. Today's proposition has been subject to significant stakeholder engagement in recent years, with formal consultations performed in October 2022 and in May of this year. This has assisted the shaping of the proposed draft amendment law to ensure that beneficial information is accessed only by the right people, is used only for relevant purposes, and is disclosable in accordance with existing practices for customer due diligence. The proposition before you is to amend the Financial Services Disclosure and Provision of Information Jersey Law 2020, which currently provides for the maintenance of the register and disclosure to competent authorities. Parallel to the development of the proposed amendment law, the Jersey Financial Services Commission has been developing the necessary system changes to bring this proposition into effect prior to the end of the year. The reasons for the amendment to the law are set out in the report attached to P49, which I will summarise shortly. In brief, it will permit the FSC to provide access to beneficial ownership information to obliged entities for the purposes of meeting their customer due diligence obligations under the Money Laundering Jersey Order 2008. So to the specific amendment in this proposition. In brief, the proposition permits the disclosure of beneficial ownership information collected under the Financial Services Disclosure and Provision of Information Jersey Law 2020 to relevant persons as defined in the Money Laundering Order and their representatives. It limits the use of this information to assisting relevant persons in meeting their customer due diligence obligations under the Money Laundering Order. It prohibits the misuse or unlawful disclosure of the information and provides offences for failure to comply. And it permits the FSC to require a person who requests or has requested information under the proposed provisions to provide evidence that supports the purpose for which the request was made. It also establishes an offence for failure to comply with such a request. Finally, the proposition makes minor corrections to existing articles within the Financial Services Disclosure and Provision of Information Jersey Law. Sir, I move the principles. Thank you.
Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? Deputy Joseph.
Thank you, sir. I was waiting for whether or not a member of the scrutiny panel who have obviously given careful and detailed consideration to this matter. So I having members will be aware, beneficial ownership is something that has been the subject of numerous debates in this Assembly, and also debates and questions from out with this Assembly, not least of which in the previous government in the United Kingdom, questions about whether or not the beneficial information should go further. That is not a debate for today, as the Assistant Minister has made clear. I absolutely support this further disclosure ability, and what I would ask, if I may, the Assistant Minister is what are the arrangements? She touched upon them in her opening remarks. What are the effectively IT and data arrangements that are being put in place? Has there been a cost? Are they on time? And are there any issues that she wishes to draw to the Assembly? Because, of course, we are aware of the sensitivity of that beneficial ownership information. I have always have had a very high regard for the JFSC and the way in which they deal with issues that we were touched on yesterday about the increasing reality of cyber attacks. I'm well aware that the JFSC has been the subject of particular increases in cyber attacks in an attempt to get that data, and I thought it might be helpful if the Minister, in the light of the enormous sensitivity of the information contained within it, whether or not she has had discussions, or the Minister's had discussions with the JFSC to ensure that every possible protection is in place, and that the JFSC have all the resources and have effectively said, yes, this is fine, because effectively what I'm imagining is that this is going to be an online access with appropriate controls to see who's seen what, etc. A bit like police records, I imagine this is to be the case, where basically there's an audit trail of who's accessed what information and when, and so therefore there can be oversight as to the accessibility, which will be of assurance to those huge numbers of individuals, both within the island and outside, whose data is held extraordinarily diligently and fully, and in a greater level of detail, because it's vetted and verified than any other place in the world, of which is something this Assembly should be rightly proud, because it is that one of been the cornerstones of our position in financial services, and has stood us well and continues to stand us well, despite other places doing things rather differently, not least of which the European Union, who was found to be wanting against the European Court of Human Rights. I'll leave it there. I hope the Minister can assist us just on the technicalities of how this will be done, because the weather is clear and I absolutely support it.
Deputy Taddy.
Thank you, sir. And I won't disappoint the Deputy Joseph. I was, in fact, waiting for him to speak first before I gave my comments. Sorry to members that I can't be there in person, but I am here otherwise. I'm going to start by reading the conclusion that our panels have put in the comments paper. Again, I hope members have had a chance to read the paper, but it's there if they want to still. And the panel understands that the draft law will allow for greater access to beneficial ownership information, enabling persons who are obliged to perform customer due diligence to carry out this function. We also agree that this is a sensible provision in aiding safeguards against financial crime and money laundering, and we understand that there are precautions in place to mitigate the misuse of access to the Jersey Financial Services Commission registry. I think this is important, just as an aside, given the breach that we had in Jersey recently that we're all aware of. I think that can only be a good thing to add to the security around that. We go on to say that further consideration for proposals of access of beneficial ownership information is anticipated in regards to legitimate interest access, whilst recommendations regarding to combating financial crime continue to develop. The panel has highlighted that further engagement with the UK, EU and other jurisdictions will be necessary And noting the consultation that's been undertaken and the government's response to the suggestions made through the process, the panel notes that there are competing international pressures on the government of Jersey when it comes to registers of beneficial ownership. The panel believes that this proposition represents an attempt by the Minister to balance privacy and human rights on the one hand, and a wider call for transparency internationally on the other. Just to add to the comments of the panel, I think one of the areas of information that we did ask for in the conversations we had with the relevant officers at the department were for considerations around whistleblowing, and in fact to make sure that there was consideration of whistleblowing activity and that would be covered. And we received a response effectively saying that is both. There are provisions currently under what's being proposed here, but there will be further considerations in that area. We can give more detail in due course, but we don't have any major concerns in that area. I'm going to continue, I suppose, in a kind of segue between what are the panel's comments in that very final paragraph and maybe some personal comments without necessarily having my scrutiny hat on. And I noted the Minister's comments and the previous speaker's comments that the talk about further potential access to the register, interesting choice of words by the Minister was by so-called legitimate interest groups or just legitimate interest. There is clearly a divergence in views internationally and with Jersey in terms of what is being asked for. And some members and some in the business community will be very aware that there was a debate in the UK Parliament only in December 2023, not just about beneficial ownership, but specifically about Crown dependencies and beneficial ownership transparency. And so whilst the two members who have spoken have said that this is not a debate for today, I would probably slightly disagree in the sense that we might not be passing any additional access to the register that others may be seeking or have talked about. But I think it is very much something which the panel and the government and the Assembly need to be aware of and should also be not shying away from talking about today, because we do need to think about not just what the current state of affairs is for this register and for Jersey being a good and leading international player, but what that might mean in the short term and in the near future. And I frame those comments just to look at perhaps one of the statements that was made by the former Minister for Security, Tom Tugendhat, in his speech on the 19th of December in Parliament in the UK, when he said that I welcome the Crown Dependency's press release stating their commitment to developing and delivering legitimate interest access to their beneficial ownership registers, confirming that access to the information of their registers will be extended to include those media and civil society organisations who can demonstrate a legitimate interest in accessing relevant information in order to combat financial crime. And he said, I look forward to seeing this commitment being adopted by the appropriate Crown dependencies parliaments. I know that it is also a fast-changing area, and I also know, sir, that there has been a ruling from the EU about compatibility with right to life, client confidentiality, and I would like to hear, I think, from the Minister in that regard, sir, when she sums up. But insofar as the scrutiny panel has looked at this, we are happy to support this proposition today, noting that it's something that we, I think certainly as a panel, but more widely as members, will need to give consideration to in the next months and years as the situation potentially develops.
Thank you very much, Deputy. Deputy Rose-Binet.
Sir, I'd just like to ask if you could lift the defo on Deputy Labby, please.
Yes, the defo is raised on Deputy Labby. Did you want to speak, though? Deputy Balash.
So I would just like to add to the remarks of the chairman of the scrutiny panel by adding my compliments to the government for its willingness to resist quite considerable pressure from other places to change our law and to make our register of beneficial ownership open to the public. We are an international business centre, and the importance of confidentiality to those who do business in the island should not be underestimated. Sometimes that right of confidentiality has to yield to other interests. And as Deputy Tadier has just said, there is a debate as to who might have legitimate interests to override the confidentiality of those who rely upon the integrity of Jersey as a business centre. The key to this, it seems to me, is that we should comply with international standards. It is international standards and not the standards of the United Kingdom Parliament or the United Kingdom government that are the crucial factors so far as Jersey is concerned. It seems to me that the government is pursuing that course. I compliment it on that decision, and I encourage it to remain firm in the face of quite improper pressure, as a matter of fact, from some individuals in another place, and ensure the integrity of our own business centre and also the integrity of Jersey's autonomy.
Thank you very much. Deputy Scott.
Thank you, sir. I'm following on from the comments of Deputy Tadier and of Deputy Balash, and I'm referring to my experience as a former chair of the Economic and International Affairs Panel too, because I would dispute with Deputy Tadier that there's been so much as a divergence of views between Jersey and the European community of which he speaks. There's been more of a convergence of views. And in this respect, as has been mentioned, Jersey has had to stand its ground in terms of explaining why there are legitimate reasons why people may wish to keep their affairs private, and the approach that we've had in the past in terms of that these small jurisdictions are covering things up. We've been easy targets, but there's only so far, and it's important to address abuse, but at the same time, there's only so far that you can take transparency. And in this respect, I might invite Deputy Tadier to think about whether he would like to live in a transparent house so that the community can check there isn't any domestic abuse happening in those. I mean, that's how far you could take it. Now, I very much urge the States Assembly to support this proposition. I very much commend the government for the leadership that it's taken in terms of holding its ground in terms of ensuring that there is this balance between what I would say is a good practice in terms of transparency, but also respecting the rights and needs of businesses and individuals to keep information confidential and to protect themselves from abuse, potentially. And I thought the panel's comments about protection for whistleblowing were interesting. I would be interested to see quite how they see that fits into the picture and who they are proposing to be protecting. In my mind, what's being presented here isn't too different from almost like what we've got in terms of subject access requests and just enabling access to information that's held on specific individuals themselves, although I'm sure the Assistant Minister may well expand on this more when she's summing up. So thank you, sir. I urge the State Assembly to support this proposition and thank government officers for their hard work in actually achieving what I think is a very good result so far.
Very much, Deputy. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Close the debate and call upon Deputy Minister to respond.
Thank you, sir. So first I'd like to thank all members who have spoken. I think certainly my sense is of overwhelming support, subject to a few comments and questions. Firstly, I would agree with Deputy Joseph that our register is indeed of a very high quality, and we should be very proud of the efforts of the FSC in ensuring that it is of the quality it is. I'm not going to draw comparisons with the UK company registers, but I think they are very different in terms of the reliability and accuracy of the information that's held regarding beneficial ownership. That is perhaps one of the reasons why the reliability of that information held in Jersey is one of the reasons why opening its availability to people who do have to do customer due diligence is going to be so beneficial to everyone who is involved in that process, including those of us, anybody who's involved in companies and seeking financial services or other services where customer due diligence is relevant. Deputy Joseph's questions about the arrangements regarding IT and data, I'm afraid I can't answer those in detail because those are matters for the FSC. I believe the FSC have been working very hard on establishing the appropriate systems and making sure that they are secure and that information will only be given to appropriate people. I'm sure they will be keeping appropriate audit trails. I would expect in very many cases the people who are requesting the information will already be registered persons with the FSC. I can't confirm that, of course, and I also can't confirm the cost. But I think in terms of system development cost, it will pay dividends in terms of the assistance it gives to businesses in the island and to customers who have to do customer due diligence. The FSC, as the Deputy says, has had a couple of difficult instances this year as regards IT issues. They are dealing with those very carefully and consistently, and have shut down any potential unauthorised access. But they will be working on that very, very carefully. I have absolutely no doubt. Deputy Taddy, again, I thank the panel for their support. He raised a particular question, which was whistleblowing. I can confirm that that nothing in this law will prevent a person whistleblowing. If a relevant person, as described in the law, wishes to make a confidential report without following the usual route, which would be to submit a suspicious activity report, they may wish not to do that for fear of reprisals from an employer, perhaps, although you would hope that's not the case. A relevant person can make a confidential report directly to a police officer, customs officer, or the Financial Intelligence Unit, and they will receive the legal protections currently set out in Article 32 of the Proceeds of Crime Jersey Law 1999. So I don't believe that these changes create any issues as regards people who feel there is something on which they need to whistleblow. I have to say, I'm afraid I don't agree with Deputy Taddy that the question of legitimate interest is not, it's not a debate for today. We do not have legitimate interest on the table at the moment. It's a complex subject, and there is considerable divergence in views. There's a divergence in views between us and the UK, and there are very wide views internationally as to what legitimate interest is. Legitimate interest, I'm scratching my memory here, legitimate interest has been stated as including media. So what does media involve? Does that include accredited media? Does it include citizen media? Does it include the blogosphere? We need to be sure that people accessing this information are people who genuinely have a legitimate interest to do so. The media, accredited media, may well form part of that as thinking develops internationally, but I don't think we are yet at that stage. Civil society organisations, NGOs, we do need to be careful that people accessing information which is of considerable value and possible sensitivity are doing so for lawful and legitimate purposes. And what we are doing in Jersey what we have done historically, which is that we are looking and we are monitoring how that thinking develops internationally. And once that thinking has developed, and once once standards have evolved and been established, we will then adopt those in a fairly timely fashion, which is what we do with everything else. It's not an area where we want to be a market leader, because that is something that could be potentially prejudicial to our industry. Legitimate interest will come back before the Assembly in due course. We're monitoring European developments in particular. That is a major block, particularly things like the 6th Money Laundering Directive in the EU. But we will watch those developments and we will respond to them in a timely fashion that suits Jersey. But that will absolutely come before the House, before the Assembly at a later date. I agree with Deputy Taddy, as I mentioned in my speech. Human rights is of critical importance here, the right to privacy and data protection rights. We are satisfied on the basis of advice we've received that there is not a human rights issue with this current proposal. I don't believe it's in breach of any human right aspect what is before us today. Lastly, sir, I'd like to thank Deputy Scott for her support, and also Deputy Balash. I'd particularly like to thank him for his comments and for his support. I absolutely agree, as I've just said, with his comments about the need for caution in terms of when, in what circumstances, and to whom this very sensitive confidential information may be released. And beneficial ownership is confidential. Would we all want the world and his dog to see our bank accounts? Possibly not. Some of us may not care, but some people will care. And I certainly do confirm that we will continue to take a very firm line about Jersey's constitutional position in this debate, and that we will continue to do what is right for Jersey, both in terms of our economic standing, our international standing, and our constitutional standing. So I assured him that we are very cognisant of those issues. So I think, sir, that concludes my remarks.
Well, Deputy Taddy has indicated I wish a point of clarification. So, Deputy, what's your point of clarification?
So I did ask about the direction of travel, and I raised the issue by quoting from the UK Parliament, who was reading a press release from the Crown Dependencies, and the question is that because the press release said that the information in our registers will be extended to include those media and civil society organisations who can demonstrate a legitimate interest in accessing relevant information in order to combat financial crime. My question is that still the position that Jersey holds? Because I think it is relevant to this debate, and it would certainly be relevant to the direction of travel in looking at this and maybe in deciding how to vote, sir. So that is the question I had asked. I don't think it's been answered directly.
Are you able to clarify that?
Thank you, sir. Yes, sorry, I would have said that I had answered that question. We are continuing to work on that. As I said, we are working on looking at international standards. I do have some notes on this. The provision of access to persons beyond obliged entities and law enforcement and tax authorities is subject to continued discussion with international standard setters and jurisdictions around the world. The human rights case law that the Deputy has mentioned has highlighted the importance of delivering a policy which is not disproportionate with interference to individual rights in pursuit of prevention of money laundering and terrorist financing, and that is not a simple matter, as I discussed. But we are observing that commitment, we made that commitment, and we are continuing to develop that policy. Development is ongoing. We are engaging with stakeholders, as well as monitoring the planned implementation of the 6th Anti-Money Laundering Directive. I'd suggest that the European Union remains probably the biggest source to look at for guidance in terms of how this is going to develop. I can confirm to the Deputy that we are not reneging on any commitments. We have made that commitment. It's important to us as an International Finance Centre that we continue to develop that, but we will do so in a timely fashion, in line with other jurisdictions. I think our own press release, and I don't have that in front of me, I think our own press release talked about making those developments within an appropriate timescale, and that appropriate timescale will be one that reflects what other people are doing, how thinking is developing internationally. I would also just say Parliament in the UK has changed dramatically since the debate that the Deputy referenced. But that has not affected our commitment. We are continuing work because it is the right thing to do, and we are doing it in line with the rest of the world. Possibly not in line with the UK's timetable, but we are doing it in line with everybody else. Thank you, sir. That helps.
Do you call for the appel?
Yes, please.
Let us call for
Yes,
invite
please.
members to return to their seats. The vote is on the principles of P49. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. And I ask the greffier to close the voting. The principles have been adopted. 44 votes pour, no votes contre, no abstentions. Deputy, I'm assuming from what has been said that your panel is not calling the matter in?
Correct, sir.
Very well. How do you wish to deal with the matter in second reading?
En bloc, if I may, sir, please.
You propose en bloc. Are they seconded?
Yes, sir.
Does any member wish to speak in second reading? Deputy Joseph.
Thank you, sir. May I seek clarification from the Minister about the issue, which I must admit I don't know. The ability for my computer's not working, so I'm just trying to get the legislation before me. The articles that deal with the definition of who the individuals or the entities that can get that information from, are we to assume that they are largely going to be regulated entity within Jersey, and are there any provisions for entities which are going to be allowed to have the access to the information, who are not resident in Jersey and not regulated by the JFSC? If they are not, if that is the case, that there's an off-island ability for entities to do it, and I'm just looking at the Attorney General, the Solicitor General, and saying if it's no, then I don't need to pursue the line of questioning. It's, but can I just ask for legal advice about whether or not it's It's only on island. So,
relevant persons are financial service providers in Jersey, so it doesn't have an extraterritorial reach.
then that's fine. I'll take my questions about how that's going to conform with the international standard, where where obliged entities which are in a different jurisdiction, that may well be something that's coming, but I'll leave that at the moment. If it's just Jersey at the moment, I can see that all the controls would be in place. Thank you, sir.
Does any other member wish to speak in second reading? No other member wishes to speak? Yes, Deputy Taddy.
Thank you, sir. I did put it in the chat just so one is aware. Thank you, sir. I think that something needs to be drawn to the attention, and I think the Minister would be, it would be helpful if the Minister could speak to it in the summing up. I could have raised it, I suppose, in the principles, but it does form part of the articles, which is the change from civil offences, which used to civil offences from criminal offences in terms of breaches under the law. And of course, I noted that there are comments from the law officers saying that there were no human rights infringements of this, but there are human rights implications of changing certain offences from criminal to civil offences. Ultimately, I think to make them more streamlined and perhaps more efficient for the purposes. So whilst the panel doesn't ultimately have a problem with the changes, I think we need to flag this up as a significant change that is happening, and it would be helpful if the Minister could speak to that. I also need to the wider so I would be straying into speaking outside of the articles, I think, if I were to try and respond to comments which might be best left for the third reading, sir. So I will limit my comments to what I've said so far at this point.
Very much, Deputy. Does any other member wish to speak on the articles in second reading? No other member wishes to speak. I close the debate and call upon Deputy Miller to respond.
Thank you, sir. I think Deputy Joseph's question has been answered, so that's fine. And I'm afraid I think Deputy Taddy's point is a rather technical legal point that I'm not quite sure about the difference between civil and criminal penalties. I think civil penalties can be applied by, my understanding is can be applied directly by the FSC rather than by coming to the court. I don't know if I could ask the Solicitor, if I may ask the Solicitor General to
by all means,
comment, please.
Well, the Commission has a range of civil penalties that it can apply. That is distinct from criminal sanctions, which lie in the power of the Attorney General to pursue.
Yes, sorry.
So, sir, I think that's. I think that concludes. I think the concept of civil penalties here are not novel, as the Solicitor General says. They exist elsewhere in financial services legislation and I think in other legislation.
Very well.
Thank you.
So you maintain the proposition?
I maintain the proposition, yes, please, sir.
Those in favour of adopting in second reading, kindly show. Those against? It's adopted in second reading. Do you move in third reading, Minister?
Yes, please, sir.
Is it seconded for third
yes,
reading? Does anyone wish to speak in third reading? Deputy Taddy. Sorry, Deputy Taddy, I assume from what you said before.
Thank you, sir.
Say something.
Yes. That's correct, sir. The third reading, of course, is to look at what's in the law as it's been passed, and maybe even what's not in the law and the direction of travel. So I found the comments of Deputy Scott not just colourful but slightly bizarre when she used the analogy of, would I want to live in a house which was completely transparent so that I could, because it would make it more difficult for me to beat my wife effectively. First of all, I think that analogy is entirely inappropriate for perhaps obvious reasons, but similarly, If there is an analogy to be made, it is that violence against domestic violence in all its forms is not a good thing, and therefore if having a house with windows stops somebody potentially being beaten or brings to justice somebody who has beaten their partner, then my sympathy would be with the victim and not with the perpetrator. And so I think if the analogy here is that we should encourage people to keep their windows and their curtains drawn whilst they're beating their partners, I think that's a very perverse thing to say from the Deputy. What I would say is that our panel and I were questioning legitimately a press release which has been put forward and which is contained within our comments and report, and which actually we did question officers about. And it's the point to be made is that it's not our comments, but the Crown dependencies, including Jersey, put out a statement saying that they were pursuing and that they would extend beneficial ownership access of registers, if you excuse the syntax there, sir, to a wider group of people if they could prove the legitimate interest. And it's incumbent on our panel to highlight that piece of work which is going on and to hold government to account, irrespective of what the politics of that might be, because that's a statement that the government has made. And our job is to make sure that we hold the government to account for the policies that they've made. And if the policy has changed...
Deputy, if I may just interrupt to make the point, you yourself have said earlier that the purpose of third reading is to discuss purely whether the law or regulation in the form as adopted in second reading should be passed into third reading or not. It's not to make more general political points relating to directions of travel about matters that are not currently before the Assembly. With that caveat, please do continue.
Thank you, sir. And so I think the culmination of my points in the third reading would be to say that this is very much a snapshot. I think the legislation we have before us in the third reading deals with the critical issues that we have identified urgently, and that we're willing to support them, and that as a panel and as an individual member of the Assembly, it is an area that we know will need to be continually looked at to make sure that the legislation is both fit for purpose and that we as an island and government and an Assembly are at the forefront of leading on this. Thank you.
Deputy Scott.
Thank you, sir. I hope the chair of the Economic and International Affairs panel is cognizant that domestic abuse can occur between both ways.
Can I respectfully suggest to members that we shouldn't be talking about domestic abuse in the context of a financial services debate?
Thank you.
And we should be purely restricting ourselves to do we pass this amendment law?
And I do believe the panel has scrutinised this matter, and the debate itself wasn't really the place for it. So I, again, support this proposition.
Thank you very much. Deputy Joseph.
Thank you, sir. I would like to address the direct issues that we are bringing into place a law, and that it is this Assembly who makes decisions about, as Deputy Balash said, about accessing information on our public registry. And I say that because it is this Assembly that makes the decisions. And some people, sir, outside of this Assembly, in other places, and I'm thinking particularly within the UK Parliament, believe that this Assembly sometimes does not exist. When I became External Relations Minister in July 2022, I was faced with an existing commitment which had been made, which had not come before this Assembly, as far as I could tell, that there was going to be a commitment, well, there was a commitment made to move towards public registers of beneficial ownership. I was rather surprised. There had been no debate in this Assembly. It is only this Assembly that can decide it, and long may that importance of this Assembly being the only entity, not a minister by ministerial order. It would be appropriate for a minister not to promise something that the states might not agree with. And I just wish to reinforce the fact that in the third reading, we have got an appropriate access which has been carefully thought about, which is in line with international standards, and that is as far as this Assembly is going today and no more. There have been no amendments that the ministers had to deal with. There has been no other matters, and this Assembly, and this is a message to parliamentarians in the United Kingdom, it's this Assembly that decides who accesses our information and not members of the UK Parliament. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak in third reading? If no other member wishes to speak in third reading, I close the debate and call upon Deputy Miller to respond.
Thank you, sir. I don't think I have anything further to say other than there's only so many times I can say we are not reneging any commitment and we will be working towards legitimate interest in due course. And I maintain the proposition, sir. Thank you.
Very well. Those in favour of adopting the appel is called for. I invite members not of the Assembly to return to their seats. The vote is on the adoption of the law in third reading. I ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. Then I ask the greffier to close the voting. The law has been adopted in third reading, 44 votes pour, no votes contre, no abstentions. Very well. The next item of public business is the Comptroller and Auditor General Board of Governance appointment of member, P50, lodged by the Chief Minister. The main respondent is the Chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the proposition.
The states are asked to decide with their opinion in accordance with Article 2.2 of the Comptroller and Auditor General Board of Governance Jersey Order 2015 to approve the recommendation of the Chief Minister and the Chair of the Public Accounts Committee to reappoint from the end of his current term of office on 25th of March 2025, Mr. Robert Tinlin, MBE, as an independent member of the Board of Governance of the Office of the Comptroller and Auditor General for a term of 5 years.
Chief Minister.
Thank you, sir. In June of this year, the C&AG Board of Governance requested that an existing independent member of the board be reappointed for a second term of office. The C&AG Board of Governance is established to keep under review whether the Comptroller and Auditor General has used and is using the resources provided to their office properly, efficiently and effectively. This is an important scrutinising function, providing assurance to the Assembly and to the public that the Jersey Audit Office continues to be run effectively. The board is composed of high calibre members, sir, and the board's running costs are low. Board members are providing their time without a remuneration, sir, and both the Chair of the Public Accounts Committee and I are grateful to all the board members for their work, and I'm sure the Assembly will join us in recognising the effective role that they continue to undertake. The proposed reappointment of Mr. Robert Tinlin for a second 5-year term has the support of the Chair of the Board, the Chair of the Jersey Appointees Commission, as well as the Comptroller and Auditor General and the Chair of the Public Accounts Committee. Sir, and Mr. Tinlin's credentials are duly listed in the accompanying report. If approved, sir, Mr. Tinlin will serve another term of 5 years following the end of his current term of office on the 25th of March 2025, sir, and I'm pleased to commend the appointment to the Assembly. Thank you.
Right, is the proposition seconded?
Yes, sir.
Does any member wish to speak on the proposition? Deputy Gardner.
Thank you, sir. Very shortly, I would like to thank to the Chief Minister of our joint work with C&AG and the Board of Governance. We're also now going to the new recruitment for the Chairman and Chairperson and another member of the Board of Governance. And on this occasion, I also would like to thank for the members of the Board of Governors, that most of them are unpaid. It's voluntary position, and they're contributing from their time and knowledge to us. So thank you. And
Does any other member wish to speak on the proposition? No other member wishes to speak? I close the debate and call upon the Chief Minister to respond.
May I thank the Chair of the Public Account Committee in return, sir, for cooperation in being able to jointly agree to extend the appointment. Thank you, sir.
Those in favour of adopting the appointment kindly show. Those against? Proposition is adopted. The final item of public business is the Jersey Police Complaints Authority appointment of Chair and Member, P52, lodged by the Minister for Justice and Home Affairs, and the main responder is the Chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read that proposition.
The States are asked to decide whether they are of opinion, in accordance with Article 2 of and the Schedule 2, the Police Complaints and Discipline Jersey Law 1999, to appoint Mr Chris Stevenson as Chair of the Jersey Police Complaints Authority and Mr Simon Burgess as a member of the authority, each for a period of 3 years, commencing immediately.
Minister.
So, before we start, may I just ask whether I have a conflict of interest being on the Jersey Police Authority?
No, I don't think you do. You don't have a direct financial interest or anything like that. I'm sorry for the...
I don't know what that is. Sorry. I just wonder whether it's odd to be on the police authority and vote for the person who may deal with police complaints. I just want to be...
I don't think that's a conflict.
Okay.
And arguably, Deputy, one will be best placed to form an assessment as to how complaints should be dealt with. So I don't think that is a conflict of interest. Thank you. Yes, Minister.
Thank you, sir. I'm pleased to recommend the appointment of Chris Stevenson as Chair and Mr Simon Burgess as member of the Jersey Police Complaints Authority. As members will be aware, the Jersey Police Complaints Authority supervises the investigation of complaints against the States of Jersey Police. This independent oversight is crucial to maintaining and building trust and confidence in our police force. The authority is constituted under the Police Complaints and Discipline Jersey Law 1999, and under the law must consist of a chair and not less than 6 and no greater than 8 members. As a result of retirements from the authority, the appointment of new members, including a chair, is required to ensure that the authority is operating within the membership levels required under the law. This also ensures that the authority has the necessary capacity to undertake its functions effectively. If these appointments are agreed by the Assembly, the authority will have 6 members in addition to the chair. Details in relation to the professional background of both nominees is included in the report, and members will see that the nominees bring skills and experience from a range of backgrounds, which will no doubt further strengthen the authority. The chair and all the members are volunteers who give up their time to serve on the authority for no remuneration. I'm deeply grateful to all of the volunteers who provided a much valued service to our community in this way. I would also like to take this opportunity to recognise all departing members of the authority for their contributions, and to pay particular tribute to the outgoing chair, Janet Naylor, who has provided dedicated, insightful leadership of the authority since her appointment in 2021. So I am pleased to recommend the appointments to the Assembly. I make the proposition.
Is the proposition seconded? Yes, sir. Deputy Catherine Curtis.
Thank you, sir. The CEHA panel would also like to thank the outgoing chair and members and appreciates their work, including their detailed annual reports, which have always been interesting reading. The panel did ask in a public hearing about agreed mitigations regarding the new chair, who is also the chair of the Jersey Appointments Commission, and any difficulties this could raise, and I wonder if the Minister could explain those mitigations to the Assembly.
Does any other member wish to speak on the proposition? Deputy Moreau.
Thank you, sir. It's just to say, it's from a personal perspective, I haven't worked with Mr. Stevenson, but Mr. Burgess I have worked with on a number of occasions, actually within the kind of world of politics in a variety of roles. And there's no question in my mind, I would not hesitate to support him. He should be an excellent member of the panel. So I just wanted to put that on record. Thank you, sir.
Does any other member wish to speak on the proposition? If no other member wishes to speak, close the debate and call upon the Minister to respond.
Thank you, sir. Yes, in relation to what was mentioned by the chair of the panel, it is, as the Deputy alluded, that the chair role is also on the Joint Appointments Commission. It has been agreed that he would not be involved in that capacity in the appointment for the process for the Chief of Police, the Deputy Chief, or any other senior officer, sir. So that would exclude him from those roles, because that would be where there could potentially be a conflict. So by stepping out of that Jersey Appointments Commission role, whilst those appointments would be made, would be the right thing to do, sir.
Maintain the proposition. Then, Minister.
Apologies, sir, I make the proposition.
Those in favour of adopting the proposition kindly show. Those against? The proposition is adopted. That concludes public business, and we come to the arrangement of future public business. And I invite the Chair of PPC to propose the arrangements for business at future meetings. Chair.
Thank you, sir. As part of the arrangements of public business, I would like to propose an in-committee debate on the e-petition Make States Old Age Pensions Exempt from Tax. This e-petition has exceeded 5,000 signatures. In fact, it's received 5,195 signatures. Sir, I make the proposition for an in-committee debate on Make the States Old Age Pensions Exempt from Tax.
Very well. Do you have a date that you wish to?
It has been proposed for the first sitting in November, which is the 12th of November.
As proposed in committee debate, is that seconded? Yes, sir. Does any member wish to speak?
So in advance of that, which obviously is a matter which is going to be important, and the facts about the reasons why, is the President of PPC, is she aware that the, and has she agreed that the Treasury that have all the information about this will be able to provide a full report, and maybe using the good officers of the GREF, maybe also be able to carry out some research for members on the instances that other places have where there is an issue about pensions, because I think members would be informed about both of those matters, and there's an important public interest in doing so, but being absolutely clear about the domestic arrangements, but also other places too.
Does any other member wish to speak on the proposition for an in-committee debate?
Sir.
Yes, Deputy.
Thank you, sir. A couple of things. One is there does need to be some guidance before to structure any in-committee debate, particularly on a topic such as this. And I have to say, sir, that my personal view on in-committee debates is we all have to remember there is no vote at the end. And the main purpose of this assembly, I think, is to vote and make decisions. There will not be a decision on this at the end of that in-committee debate. I think everybody needs to recognise that. I think this is something for our, if we're going to have a system of, I've forgotten what they're called, petitions. So I have a concern that a petition system makes people believe that by coming up with that petition at the end, they will have an outcome that is tangible. Now, one might say that it is a tangible outcome to have a debate on this, but I just say I think the tangible outcome is to vote and make decisions, and that won't be happening in this debate. I just want to put that on public record, sir, because that's a view that I hold. Thank you.
Deputy Conatarbison-Brulak.
Thank you, sir. Given there may be one or two members in receipt of old age pensions, what would your ruling be on their participation in this debate?
Well, I think the position is that although, well, firstly, no decision will be made in an in-committee debate, therefore there will be no vote taken, and all that will be is an expression of views by members. So nothing will change as a result of the in-committee debate. Secondly, even if it were otherwise, my instinct is that whereas some members may direct particularly benefit if there were a vote in a particular direction. It is an interest that it will be shared by a very large number of people, probably everyone in the chamber at some point, even if not a million. Some will be rather more distant than others, but it's shared by every member in the of society, to a very great extent anyway, and therefore it seems to me it falls in the same provision that a debate on a tax is likely to fall, and there would not be a conflict. That would be my view. I'm happy to consider it further as we go, but that's my first blush reaction. Very well, Deputy Tadier.
Thank you, sir. It is quite rare that a petition gets to 5,000. Getting to 1,000 in itself is quite a feat, which, of course, we know requires a ministerial response, an official response. So it's worth noting that we may be overtaken by events anyway. So the comments of Deputy Ward were well made, I thought, Deputy Rob Ward, insofar as that, of course, there won't be a debate, a vote on the debate. But if we think about the days before virtual petitions were in existence, there was always, and there remains, the option of a paper petition, which only needed, I think, indeed one petitioner, but of course they tended to have more. And what would often happen is that paper petition would be handed to a states member often, and the states member who supported the aim of the proposition would themselves lodge a proposition along with the petition, and there would actually be a debate with a vote at the end of it on that petition. I've done it myself and have been successful on at least one local issue in doing so by representing the views of the petitioners. So I think it's important that as we come up to Democracy Week, that that message is perhaps reiterated by the States Gref, that there are a number, and including maybe the chair of PPC, that there are a number of democratic tools that can be used to determine different outcomes, notwithstanding the good old-fashioned paper proposition, or indeed finding a sympathetic states member who would be willing to sponsor such a proposition.
Very much, Deputy. Deputy Barbara Ward.
Yeah, thank you, sir. It's important and respectful that the wishes of the signatories under the procedures have this openly debated. The number from the electronic survey really only reflects those who are able to access an electronic device, a computer. Therefore, the number may well be much larger. For the future, may I ask the Greffier that consideration be given to those islanders that are in this situation, the opportunity to sign a petition in person at, say, their parish hall, and that their votes are added to electronic results for all future petitions. To have a full debate on the subject and to hear all members' views, for or against, can only be good. This debate is essential to respect the views of islanders. After all, it's the islanders, especially the older generation, who tend to be the people who turn up to vote in island elections. Their voices need to be heard. Thank you, sir.
Deputy Moreau.
Thank you, sir. It was just to say that whilst I agree that we are here to make decisions, I would also believe that those decisions cannot be made well if there is no discussion beforehand. And certainly one of the really good things about an in-committee debate is it gives the opportunity to just talk about the issue, which is something I fear that in my 6 years as an Assembly member, I don't think we do enough as States members. I don't think we actually talk about the issues enough. And so I wouldn't criticise an in-committee debate because there is no vote. I'd say it just creates another form of debate, one which will probably be freer, and allow all members to properly express their views, which can then be taken into account if either a member or the government, a minister, wishes to bring a proposition on that subject forward at a later date. So I think there is value in that.
Deputy Miller.
Thank you, sir. I think Deputy Morell has made some of the points I was going to make, which is I think a debate will be useful in the context of garnering members' views. Any change to tax can be very much more complicated than it appears on paper. And clearly, my feeling would be that if we had a debate and the overwhelming view of the Assembly was in favour or against, that would then lead into whether or not someone, government or otherwise, brought a proposition. And I would strongly suggest that if anybody was going to bring a proposition about this, that would properly sit with the Minister for Treasury and Resources, and the members would be able to give that message very clearly as part of that debate. And then any further amendments would then be prioritised within our existing workflow. So that's my only observation, sir. Thank you.
Very much. Deputy Hall.
It seems rather strange, sir, but please could I raise the defo on Deputy Jeune? Thank you.
Yes, all right. Indeed. Did you wish to speak?
Members excuse it anyway.
I'd just like to mirror the views of Deputy Morel, because I think it is important that we do discuss things in this chamber. My family say, why can't you all get together? Why can't you have a proper talk? That's what you're there for. Thank you, sir.
Yes, I might make the observation. I had automatically said yes without giving it a moment's thought, because Deputy Jeune was excusé. And if you're excusé, you don't need to, you're not on default. The default doesn't need to be raised. You get here when you get here. Just to inform members for future reference, Deputy Scott.
Thank you, sir. I just support what Deputy Morel was saying. Just wanted to add something also in response to Deputy Rob Ward's position, that if you have a vote that's in response to a proposition, if a proposition is defeated, then it's another 3 months before you can take a proposition on the same subject, in which case, you know, it's testing the water all the time and having these delays. So that's really the value of an input committee debate, so that a proposition, the water can be tested, a proposition formulated in response. I therefore support that proposition. Thanks.
Does any other member wish to speak on the proposition for an in-committee debate? Deputy Balash.
So I must say I incline to the views of Deputy Ward and Deputy Tadier, because it seems to me that the petitioners who have signed this petition expect a decision from the states. And if we have an in-committee debate, there is, by definition, no decision. I agree with mental blank Deputy Morel. Thank you.
Yes.
I agree with Deputy Morel that it should be an informed debate, but it seems to me that the best way to achieve that end is to encourage the petitioners to find a member of the Assembly who can put forward a proposition seeking the introduction of this change. That member would then presumably add a report to the proposition, which would enhance the short reasons set out in the petition, and the appropriate ministry would have an opportunity to lodge a report setting out its view on the proposal. And then we have all the written information before the Assembly. We can have a proper debate and make a decision.
Does any other member wish to speak on the proposition to hold an in-committee debate? No other member wishes to speak? Then I close that debate and call upon the Chair of PPC to respond.
I thank all the members who have made their opinions clear with this, and I'd just like to say that as Chair of PPC, it's my duty, but not within my gift, to force a vote on this. So, and I think it's fair and democratic to the petitioners, over 5,000 petitioners, to bring this forward. And the only way I can do that is to propose an in-committee debate. Otherwise, we could just completely ignore them. No States member, as far as I'm aware, has decided that they will bring this as a proposition. So I think it's beholden to us. It's not, it's not ideal having an in-committee debate, and but this is the fairest way of airing this. I take Deputy Barbara Ward's points about having petitions at parish and public halls. and I'll take that to the next committee to Conor Tarbs. It is beholden on, members can bring a proposition if they'd like to. I've also like to reassure Deputy Ozef that I've discussed this with the Treasury Minister and the GREF, and that guidance will be given before the debate, which is why the debate has been scheduled for the 12th of November. I thank Deputy Morel and other members, and so I make the proposition. Thank you.
Those in favour of an in-committee debate kindly show. Those against? Well, definitely it's passed on a show. So, yes, there will be an in-committee debate. The rest of public business, Joe?
Thank you, sir, and I thank everybody for agreeing to the in-committee debate. At the moment, we have 6 items listed for the next sitting on the 1st of October. Delivery of 3 bilingual primary schools, P45 2024. Nationality Acts extension to Jersey, P55 2024. Social Security Medical Appeal Tribunal, P57 2024. Income Support Medical Appeal Tribunal, P58 2024. Westway Trust, transfer of the assets to the Don DeFay Trust, P60 2024. Capital gains tax on the sale of residential property that is not a main residence, P61 2024. Sir, I propose the arrangement of public business.
Well, are those seconded? Deputy Ozef, do you wish to speak?
I'm aware that we are just dealing with the arrangements of public business for the next sitting, and one doesn't set any arrangements for future business. But bearing in mind the previous discussion, I wonder if I could ask that the chair of PPC would give consideration, now the Assembly has agreed for the proposition, the in-committee debate, that mindful of the lodging of the budget and the necessary arrangements that could be taken for that, which is scheduled for the 26th, and I'm not proposing that they change it, but maybe she would give consideration to bringing forward the in-committee debate in order to allow an amendment, should it be necessary, to the budget, which will not be able to be done if the in-committee debate is held on the 12th of November. There's no real time to actually do this. I'll take this offline, but just so that there's an awareness, we're only setting business for the next sitting. Yes. But
I think you've made the point, Deputy, and I think that's for the chair of PPC to consider together with you outside the context of a formal sitting. Does any other member wish to speak on public business? Very well. The arrangements for public business are adopted, and the Assembly, having concluded its business, stands adjourned until 9:30 a.m. on the 1st of October.